Hi guys, sorry I'm in the dark.
Hello.
Hi.
This is really dad.
Hi Maku.
Alexis Ellinger.
Joined the meeting.
Hi Janet. I sent Claude a text.
Okay, good deal.
He said, oh, he wasn't him. Somebody else responded.
Okay.
Oh, he's logging on now, he said.
Cool.
There he is.
There he is.
Do I need to unmute it? All you all are muted.
Yeah, that's on purpose. You don't
Oh,
want to hear
okay.
what's going on out here.
Oh gosh.
Hi Tina. Brian. Kelsey.
Hey, Brian.
Happy birthday, Tina Woken.
Wow, happy birthday.
Happy birthday.
Thank you.
Give him 1 more minute, Susan.
Okay, gotcha.
Hi Sherry.
Maybe I ought to get something so I can write things down if I can't, because I can't remember things.
Hi Sarah. Welcome.
Glad to see you here, Sarah. Everybody, Sarah is going to be in our next CASA training class. She's getting a head start.
Oh,
Hey,
I was actually thinking, who is that? I don't know her. We'll know each other soon enough.
Absolutely.
Yeah.
Thanks for joining
Glad
us.
to
Yeah.
have you on.
It's Marcia and
I'm
Terry.
glad to be here. I'm really excited about it.
That's awesome. You'll love it.
I know I will.
All right, you can go ahead and start, Susan. People might be jumping on as we go. We have
Okay.
one board member with us so far that I can see, Charlotte Burton. And
Charlotte.
we have staff and advocates, and Evan Holcomb is a therapist, and Claude. So I think we are ready to go.
Okay.
hey.
There you go. I was just about to say, Claude walked away right when we were getting.
Now, I wanted to get something to write on. I thought maybe I should. I don't know.
I understand. Well, we want to welcome everyone again this week to our social Zoom hour. So thankful for you to be participating and welcome your feedback. This week, we're really excited to have our distinguished guest, County Attorney Claude Porter.
I wouldn't go that far.
And we're really going to today try to be talking about court procedures and what all is taking place with the pandemic and courts in general. And I'm so happy that we have a brand new person that's going to be coming on with as an advocate, because I'm sure she probably isn't aware of a lot of the court procedures, especially during a pandemic, but just during typical times. So it's a good time to have this meeting. And I just wanted to say, Claude, while many of us work closely with you and recognize that, you know, some of the procedures of the courts, a lot of our advocates obviously have never had any experience with the courtroom setting prior to becoming an advocate. So therefore, we wanted to kind of open with maybe if you could just give us an idea of the process of family court
Okay.
and what your role in family court is.
Okay. Well, let's start with the process. It starts with an investigation, normally by the cabinet, but anybody can file a petition that gets into the court. And the petition is the document that says there's some problem with the kids, usually, about what's going on or the care. And there are two levels of care or petitions. One is an abuse or neglect. And there are seven different kinds of abuse or neglect or methods, and the other is a dependency. You will hear often that my position is all we need is an order from the court, and it's often the lawyers will go along with a dependency finding rather than trying to get an abuse or neglect, because that makes some difference in some people's employment. So when someone believes that a child is abused or neglected or dependent, that is under improper care, control, or fits one or the other, sexually abused, physically abused, emotionally abused, not being provided proper care or control as a result of family member, even medical attention's not being provided. Often these are related to drugs. The cabinet or a grandparent or any other relative can file a petition. In fact, I think you all have filed, or CASA, either, I don't remember whether it was an employee or a volunteer who's filed a petition in the past. Law enforcement has filed it, but normally it's the cabinet. They are the premier, or they file most of them. Once it's filed, and you can ask, and the cabinet often does ask for what's called the temporary removal. They ask for an emergency custody order, or we speak in a language much like everybody else. They have their own language. And you'll see ECOs, TRHs, TROs, AHs. Those are all just acronyms for what we're doing. The first part of that is an emergency custody order, an ECO. The judge reviews the petition and decides whether to grant the cabinet or anybody else emergency custody, and then we have to have a hearing within 72 hours. At that 72-hour hearing, the court then decides whether the removal was reasonable under the circumstances, and whether to continue the child in a place other than the parents or whoever the caretaker was, because it doesn't have to be a parent. It can be anyone who's providing care for the child. It can be a PECCS, another one of those acronyms, a person exercising care, custody, and support. And those are often grandparents, neighbors, aunts, uncles, fictive kin. And if they believe that there is a reason to continue them out of home care, there is a temporary removal order, a TRO, entered. Once that order is entered, we then set an adjudication hearing, and we try to do that within 30 days because we have 45 days. The court has 45 days to enter an order, to enter a dispositional order. And a dispositional order is an order that says what the parents or whoever it is are going to do to try to get the kids back. So once there's a temporary removal and their lawyer's appointed, we have a hearing about that, or we all agree. The adjudication is set. That's the time when the court determines whether there is enough to believe that the children, the parents, have done enough so that the court can take jurisdiction, authority over the parents to say, you have to do certain things. That's the order that's entered, the adjudication order. At that point, they'll make another decision about whether to continue the children either in the out-of-home care or return them to the parents or persons who had them before. The next stage is a dispositional hearing or review. The cabinet normally, although occasionally if there's a third-party petition, someone other than the cabinet who filed it will make recommendations about what they think the parents or the persons who were charged, the persons who had custody of the children at the time that the first order was entered, the temporary removal was entered, what they have to do. And I would say, 8 times out of 10, it has something to do with drugs. So they have to get usually a substance abuse assessment, a mental health assessment, oftentimes, not always, and follow then the results of those assessments. Most, if not all the times, the dispositional review, the sticking point has to do with who's going to have custody of the kid. Does the child or children remain with the person who has custody, often the cabinet, often sometimes a third party who filed it, or do they return to the parents awaiting their completion of all of the requirements? And we are required as part of the law is to get these kids back into their home as soon as possible, but weighing the benefits of returning, the cost of returning, and the parents' ability to handle the kids. So once a disposition has been entered, and once adjudication occurs, the court then will appoint CASA. CASA then has an obligation or duty, whatever, to see the kids and report to the court about what they see and how the parents are interacting, how they're complying. Is the cabinet allowing them visits? Are they showing up with the visits? How's the kid doing in their placement? Are they in school? Are they following through with the school? Are the kids getting the mental health treatment they're supposed to? Are the kids getting their therapy appointments? Are they seeing the other kids if they're separated? All of those kinds of issues. And you all have done, I think, a pretty good job about filling out the forms and getting the forms in and showing us what it is that you see. So after the disposition, then we just review. We're looking to see how well the parents follow through with those plans that either the cabinet or the court set out for them. Kid can be placed in, a group home, in a foster care home with a relative, or back at home, depending on the circumstance. And then we're just monitoring that for the length of time it takes to see whether we can return the kids. And then usually, even after returning, we do that. If they're not returned and they're out for at least up to a year, the federal law says that we have to have a plan to decide when is termination going to start. We have to have what are called annual permanency reviews. Those reviews look at the placement, visitation, whether the parents are following through with their case plans, whether they're doing what they're supposed to. If they are, we're looking at ending that and returning the kids. If not, where the cabinet's looking, particularly the cabinet is looking at possible terminations of the parents' parental rights. And after a year, if they haven't done anything, the cabinet often begins those termination proceedings. The persons who are not the cabinet, who are fictive kin or relatives, may often start permanent custody proceedings, and the court may award those people permanent custody. Once that's done, we're out. The court is out. We close the case, and we move not on to the next one, but just take the next one on its way. And that's basically in about 5 minutes what usually takes somewhere anywhere from 7 or 8 months to 18 to 24 months for that to happen. So is that, Susan, is that?
That's Evan's applauding, so that must have been a really good synopsis of the court system. And for those of you that are on, most of you do know because you have been through a court case, and there's some new folks on here. Typically, all of those things that Claude was talking about with all the different types of hearings take place at the Judicial Center in the family courtroom. Normally, if you've ever been there, the hallways are packed with people. There's,
Right.
multiple cases throughout the day that are taking place. My next question is, can you kind of give everybody an idea, for those that haven't had a case happening right now during a pandemic, of what a court looks like currently and will until this quarantine is lifted?
And yes, and this is not official yet, but we are hearing that this is going to last through the end of June right now.
That was one of my questions. So
Yeah. So basically, the court proceedings now, we're only doing temporary removal hearings, adjudication hearings, and dispositional hearings, the things that are time sensitive that are required to be done within a certain amount of time. Reviews, generally we are not doing reviews, and all of those hearings are done just like we're doing them now. They're done on Skype rather than Zoom, but it doesn't make any difference. They're all done remotely. No one is in the courtroom. Up until recently, even the judge was not in the courtroom, and lately she's been doing hers from her office, and the others, her staff has been working from the office rather than at home as well. So we have hearings like this. We will, I think some of you all have participated in some of these. You'll get a Skype notification and invitation. We'll have a hearing close to the time that is scheduled. If we had a hearing today scheduled at 3, we would try to do those. Somebody will get on and we'll try to work through them. It's often that the judge will move from one to the other. I have another person who's helping me. You all may know Devin Calitri. She's been helping me. And so we sometimes split the cases if we have to, but we have to be on all of them that are moving. We also try to discuss with the lawyers and the parties some kind of resolution or some way that we are going to continue, or either if it's a temporary removal, whether to enter a removal order, whether someone is willing to admit to dependency, move and get an adjudication, or whether they're willing to accept the disposition that the cabinet or whoever recommends. But we have a hearing just like this. Each one are scheduled for a time and a place. So normally when we may have 30 to 35 hearings on Tuesday, we have somewhere between 10 and 12. And last Tuesday I think we had 12, including the removals, and we were there till almost 5 o'clock. And that was without a break. It takes a little longer with a meeting like this, because oftentimes when we're in court, we have 2 or 3 groups of cases, including the lawyers involved in doing all of them. And when we have the Zoom, you have to be on them and the judge has to be there. So we are doing each one of those one at a time, and they're trying to set them about 30 minutes apart. And most of the time 30 minutes is enough, but often we'll have to have hearings and they will last an hour or so occasionally. We don't like them to, but they do. And it looks like that will continue. Again, I don't have an official word from the Supreme Court, but it looks like that's going to continue to the 1st of July.
Okay. Well, thank you. We appreciate that.
Yeah.
And with what you were saying, with just doing the temporary removals and adjudications and dispose, and not necessarily the reviews, we've had this come up in our group, and we actually had a Zoom at 12 today and talked with some others. Carolina was on it about, and I was going to just follow up with you as well about the reviews all being postponed. And we realized there are circumstances, like I know last week I had a case that we felt like needed to be seen, even though it was reviewed. There had been some circumstances that had changed. We reached out and were able to get that to go ahead, and that's going to have, that hearing will take place. Specifically though, the hearings we have that are reviews that possibly could end the case that are being set out, we as CASA are trying to figure out how we can go ahead and get some of those to take place that would wrap up the case, and reunification could take place, and the case could pretty much close. So is there, without just putting all of those off and then having this huge influx of those types of cases, is there anything we can do to kind of get that case before the court?
File your report, file it well ahead of time if possible. So at least the week before. So if it's on, like if it's on the 26th or whatever it is of May, if you could file it this coming Tuesday and say that, and the cabinet supports that, we might be able to get those and get the judge to put those on and end them, because that is one of the things we'd like to do. If we can avoid having that case come back again later, that's just one more case that we do not have to hear. And it's always good, if that's the issue, is to return the children and put them back in the home. Yeah. So I think if you can get a report in that says that, showing what it is, at least a week ahead of time, I think we might be able to put them on and do that.
Gotcha. Okay. It didn't tell everyone, but I think a lot of our folks on already know, but there is a chat box at the bottom of your screen. If you have questions, if anything that Claude is saying.
Let me go down here.
Yeah, if you have questions, you can just, there's currently not that any right now. Rosemary did send one, but I'll check it out here in a minute. But if you have questions for Claude, if you want to raise your hand and I can see you, I don't think I can see everybody, but, or else shoot it out there on the chat box and we'll definitely talk to Claude and get the answers for those. I specifically have a case that I was curious about on drug testing. This was, as you said earlier, most of our cases do, the large majority involve some type of drugs that are happening in the home. And typically, if this courts were happening in the courtroom, many times, as most of you know, the judge will order a court or drug test on the spot, or she has them sending drug tests in. So she has a little bit of an idea of if they're complying or not. During this period of time, what are they doing about that? If we come in for, say, an adjudication or a disposition and the removal has been due to methamphetamines, how are we handling that? Of course, they're going to come in and say they're not using, but how are we assuring that?
The family court drug testing continues. We've agreed, they were doing it in our office, and we've agreed that they can continue those, except the timing is different. They were doing them during the day, and there's some people in the office who were been out of shape about it, but we've arranged, excuse me, we've arranged for the drug testers to come in after 4 and on weekends. So they're testing. They tested yesterday. They tested at least once and not maybe twice this week. And I can't remember if they were going to test tonight or not. But they come in at 4 o'clock or after. So they're scheduling. They're still scheduled to appear for drug tests. There would not be an ability at a court or like a Zoom meeting like she often did and send them over during the hearing and ask for a test, because we do not have them available, and they're not available during the day in the office.
And I think that's one of the concerns that the family I'm specifically working with that I'm talking about, their concern is, and those of us who sat in on lots of court cases are aware that most of the time the individuals that are being tested will be prepared to be tested if they know it's coming.
Right.
So how is that if
Those, the ones at night are random, are still randomly chosen or drawn or scheduled. So they don't know exactly when those are. At least as far as I know, there's still a random distribution of those testings at night. But again, we do not test them at a hearing now because we don't have the capability.
Okay. Okay, I'm going to jump over here. It looks like we've got some questions in the chat box, and one of them was, speaking of the Supreme Court, how do you feel about the Wisconsin Supreme Court ruling that the shelter-in-place orders are illegal and unenforceable by state government? And do you see Kentucky doing something similar?
About stay-at-home orders, I don't think ours is going to change much. I mean, we've had a couple of Sixth Circuit cases, mostly having to do with religious proceedings, and the primary one was allowing drive-in proceedings, people to show up at drive-ins, but all religious, I think all churches can open this weekend. It's either this weekend or next weekend. I think it's this.
Yeah, I think it is this weekend.
Yeah. And I don't have the copy of the order in front of me, so I don't know that that's going to become an issue. The stay-at-homes, the only time that I've had to try to enforce one was against a commercial property, and I just cajoled and talked to and threatened or whatever the people in Dallas, and they agreed to follow through with the plan. So we haven't charged anybody, haven't done anything. It's unlikely we're going to, unless it just becomes persistent, obvious, persistent, and willful. So.
Okay, we've got another question. Do you see racial disparity? Sorry, it jumped on me there. Racial disparity in reporting and removal of African American children in general in Daviess County?
Short answer is yes. There's a higher number of ones that we have in proportion to, I think our population is somewhere in the neighborhood of 4 to 5%, and the number of reports or cases we have is probably double or triple that.
All right.
So there is a disparity.
Another question, what all do you do as the county attorney, and how many other hats do you wear?
Okay, we prosecute traffic and criminal part. We are the prosecutor, whatever, for disability proceedings, mental health proceedings. I also we filed one today for people who are refusing to get medical treatment, adults who are refusing to get medical treatment. We handle child support, which is about half of my office. I represent every one of the constitutional officers. I answer the office answers calls from, and we write warrants for every one of the law enforcement agencies in Daviess County. We answer their questions. Let's see. I represent fiscal court as its attorney, so I'm the lawyer for an agency that has about a $70 million budget and 250 employees. So for whatever kind of business that is, we have all of those questions and things. I supervise all of the elections, and so that's one of the things we're getting ready to do now. I collect delinquent taxes.
So you have lots of time for Zooms, is what you're saying.
Yeah, sure. Yeah. Well, I do have 28 employees, so that helps. And they're doing a lot of that stuff, but I do more of those now. And yeah.
Gotcha.
Okay,
so here's one.
That's most of what we do.
Okay. We've got one here from one of our advocates is also on the Citizens Foster Care Review Board and was recently reviewed a child that had been in foster care for 3 years. The mother does not, I'm sorry, I'm losing my track. The mother does just enough to keep things going along, but they're all appalled that this child who's doing well in foster care might have to eventually go back with mother who's not followed her case plan consistently for 3 years.
So how old is the child first? Do you know?
Terry, do you want to jump in? It's her case. I'm just reading. I'm not sure. You're muted. There you go.
I actually think, is this Robin and Steve? Is this the phone call that you guys were in on? I can't remember if that was.
Yes. Yep. You
Yeah, yeah, it is. That's the one.
How old is the child?
Paula and I were on the review board, but it was Steve and Robin.
Yeah.
They are 9 and 3. 9-year-old girl.
They're young enough that's one.
No, she's 12.
Oh, sorry, 12.
Robin.
The two are the two are together in the same place.
Yes, they are.
Normally, when they're that young, they've been in that long. We do a permanency review, and the cabinet has already started it, because once they're in foster care for after 12 months, and for 12 or 15 months, they're supposed to start termination proceedings.
Yes, I know that. But what happened is that the worker canceled the TPR and is working with mom, trying to get her back, even though it took her a year and a half to get into therapy.
Well, and that's one of those things where the cabinet looks at it and says, are they doing enough that if I filed a termination, that the court is going to say, well, she's following through, you're going to have to go through and see if she'll follow through with these. And that may be what it is. When's our last APR?
We were supposed to meet in May 5th, but of course with the academic, we couldn't do that.
Normally on APRs, we try to do those. What's the name? Let me just check on it.
Okay, it's a Harris King case.
Okay, I think that's on sometime. I'll have to look. I can't get to I've got my folder in my notes, and I'll take a look at it. There's two.
But I tell you right now, the mother came back after a year and a half and decided she's going to do her therapy. And then the social worker decides that she's going to go through all of this, and even doesn't see the red flags about some of the things she's not following. And she's still trying to get the custody to the mother.
Well, I remember the name. I thought we just had it, but maybe it was just because I put it in and we reset it. Let me take a look, and I'll see if I can send Susan or Rosemary or Kelsey or somebody, and then whatever I can find out.
I just wondered, because I know that there's time length, and it's going way beyond that time length.
Yeah, sounds like it, and that's a little unusual. But it could have been one that's come in, come out. I don't know. I do remember the name, though.
Okay.
I'll check, Steve.
Yeah, if you just want to let me know. And as we move forward, if you guys, when you're discussing your cases, try not to elaborate to the point of breaching confidentiality.
Yeah.
No.
I mean, all of you have signed the agreement, so it's not so bad. But
I have another question. What happens when the home of removal is for both parents, but the children are only returned to one parent due to the other one not following their case plan? Is it legal and acceptable for the children to be unsupervised with that other parent that didn't follow their case plan, even if the court never made it that far with the parent?
Okay, so what we need to do is look at the order to determine what obligations each parent had and what were the terms of the agreement or the disposition and the review. So the order should specify the terms under which the non-custodial parent has contact, visitation, parenting time with the kids, and what conditions there are. So there is no normal. Everything depends on each case specifically, generally, and if one parent has not followed through and the other parent has custody, usually the parent with the custody is very persnickety about how the other one visits and letting the court know about what's going on or not going on with the other parent. So I can't answer it generally other than say we need to look at the order and find out what that order says and find out if the person without the child is following the terms of that order and whether the parent with the child is following the terms. Because we say one parent's persnickety about it, it can be exactly the opposite too, that the parent is just as willing to say, well, there's nothing wrong with mom or dad. I'm going to let them see mom or dad, and they're not supposed to. That may result in another removal because they're not following the terms and conditions of the court's order.
Right. Gotcha. Okay, I have some questions that were actually emailed in, so I'm not
Okay.
sure who sent these, but if I ask the question and whoever is sent this is on and needs further verification, jump in, feel free to jump in. Can you explain why and you may not have the answers to this one, Claude,
Okay.
but I'm going to ask it because it was sent in. Can you explain why family court adoption process is different from private adoption? And do you know if there are less background checks, family home visits, in other words, less hoops to jump through?
No, regardless of whether it's a private adoption or they all have to go through family court. All adoptions have to go through family court. The family, if you do, when you say a private adoption, all that means is that you haven't had the state intervene and do it. You haven't asked them to do that. There's a private agency that's set up that has the child, that's set up the arrangements, that's done the social services report, that's done all the reports. They still have to go through family court. They still have to get the same kinds of orders. There's not really any difference in the last part of the process. It's the first part about who was handling the reports to the court and where the child was, for who placed the child with the proposed adoptive parents. So that's a nutshell of what it is.
Okay, gotcha. Another one that was sent in is, what do you think is the most challenging part of family court as opposed to other courts? I don't know if it would be opposed or just in general.
I deciding what the right thing to do is, figuring out how to gauge, how to determine the right kind of thing to do for somebody. I mean, how do you know when you do an emergency custody? Are you doing it and giving it to the right people? Do they know what they're doing? How much do we know about when we set this up, whether people are following through? When to quit, when to keep going. I guess those are the hardest things, because we're dealing with people's families, and we're splitting them up and trying to put them back together, and it's, we're sewing with stuff that we have no idea what it is, and we're using great big loops, and we're leaving lots of scars.
Gotcha. Another one that was sent in is, at what point do we stop arresting parents for non-compliance and focus on permanency for the children?
Case by case generally, but it depends on the length of time. The longer the parents have failed to comply, the more likely it is, at least the cabinet and I will ask for the court to intervene and say, look, it's time to quit. Sometimes the guardian ad litem will do that, but I don't know if I can give you a specific times. I would say that we probably have to give them the length of time that the federal government says, at least in the adoption. We probably are looking at that 12 months. Once it's past the 12 months, then it's a whole lot different game. I think it's a whole more likely that we're just going to say, we're done. And that's what sort of bothers me about the one with 3 years. That seems like a long time.
Can you, I'm sorry, I didn't mean to interrupt you, but just saying that, can you explain to a lot of our guests on here what the dispensing with reasonable efforts is? I don't know that everyone's so familiar with that.
There's a provision in the statutes that says that the cabinet, if the cabinet is involved and is trying to help and provide services to a parent who is under the court's order to get certain things done, drug testing, parenting, whatever it might be, and they're not following through, they're not responding to them, they're not helping, they're just not doing anything, the cabinet through us will file a motion to dispense with reasonable effort, saying that the cabinet is no longer required to help that person complete their dispositional recommendations. That doesn't mean that they can't complete them. It's just that now the cabinet is not helping them. They're moving on to another family who does want some help and does need some help. And that's a precursor often to a termination proceeding.
Okay. And just to kind of piggyback on that, do you feel like at times maybe the parents have more rights than the child in some of these family court hearings?
I can see how somebody would say that. Yeah, I can see that to some extent. Yeah. because the parents are the one that are before the court in essence, and they're the ones whose rights are being determined, because the Supreme Court says that parenting is a primary right and we can't just willy-nilly take them away. So we're under some obligation to do that, and they're the ones before the court. The kids are they're the part that says, all right, the kids are before the court, but they're not technically parties. We don't tell the kids what they have to do. We tell the parents what they have to do to have the children back to the parents. So yeah, in some ways there's some of that.
Okay. Do you see from a procedural standpoint that cases move through the court system more quickly or less quickly, more slow, based on the fact of whether or not the child is in custody of the cabinet, or if it's been a fictive kin placement and a third party?
There's a difference in the way that we can set reviews if the child is with a relative and not with the cabinet. They're both out of home, but with the cabinet, and if they're in an institutional setting, we are required to have a review and a hearing every 60 days. If they're with a parent, we can set the reviews off as much as 6 months. So we don't review as often. So in some ways, yes, that's true. I don't know that they move more quickly, but we have more reviews and more eyes on the ones that are in a place other than with a relative or with even fictive kin, because if they're with a cabinet, we're required to review more often.
Somebody saying something? Sorry, I thought somebody was asking a question there. Okay, if the case is set for a TPR and DCBS wants to send the child home, is it possible to get the judge to change their mind during one court hearing?
I think that's happened before, so yes.
Okay.
I haven't seen that happen too often, and I don't do the terminations anymore. I don't do the contested terminations. I used to do all the cabinets agreed ones, but they have their own lawyer now in-house.
Okay.
But the contested ones, but yes, that's a possibility.
Okay, good. Okay, I've got one that is asking, since our county is on the state border, how do you see the family court differ from the Indiana family courts here in Kentucky?
Well, I don't know exactly. The Indiana really has basically the same set of statutes that we do, at least from the ones I've looked at. Most of that has to do with the judges. And in courts, we have 5 different judges, and we'll have 5 different opinions about how it's to be done. When you go to another county, they have another opinion about how it is. They have a different prosecutor. So everybody sort of, even though the laws are exactly the same, they're not quite cookie cutters. Like in some ways, maybe they should be, but this is hard to do much with cookie cutter stuff. This is like picking up Jell-O and trying to mold it outside of a bowl. I mean, that's what we're trying to do. And so all of us are just have our hands on it, and it's melting at the same time that we have it in our hands and trying to push it. And so we're trying to push the Jell-O through a fairly small tube, and it's not going to work very well. And we're going to have a big mess, and we do have a mess. And we just try to reduce the mess that we have and try to at least do it as much as we can the same every time for everybody. But again, a lot of it is all specific to the facts and the cases that we have.
Gotcha.
And we try to apply that same stuff to each one of them.
Gotcha. Okay, we have another one. When are child abuse victims in criminal court versus family court? And if the parent is the perpetrator, is that
They're usually both. They're usually both. If a parent is named as the perpetrator on the criminal one, yes, they'll be in both. And what we normally do is that's one where we often are treating that one more gingerly, trying to work out to get the criminal case worked out without doing too much to keep the family court case from just stalling. I've gotten so, and most of the lawyers are willing to do an agreement to say that the child and family court is dependent. We enter some orders, and then we agree not to use any of those findings or adjudications as part of the criminal case, and then we deal with the criminal case somewhere else. There have been a few times where I've had really severe criminal ones, and I just dismiss the family court case because the child is with a parent who's a protector or whatever, and the other parent they're going to get a lot of time, or they're going to get, I know that. I don't even want to, if they're going to try to ask for a hearing down here, I don't want to do it because we do not prep the child how to testify in the family court in the same way that they're going to in a criminal one. And I will not let the lawyer here try to get the child to say something that keeps them from being able to say something different in the criminal case. So I often just dismiss them if we're fairly confident that that criminal one is going to trial and that there's going to be a conviction. If there's not, we can always come back.
Gotcha. Okay. All right.
And I'm sure that I answered that question, but.
Yeah, you did.
Okay.
Okay. Are you seeing any trends in child abuse and neglect cases over the last 30 years of service to our county? And I see that you're only 40.
There was a lot more drugs involved in the last few years. A lot more meth. Surprise.
Right.
And it's just,
right.
Yeah.
Yeah.
And it's just, yeah.
Okay. All right. Does anybody have any other questions for Claude? That's the last one I see on the chat board, but you're welcome. Evan, go ahead.
Well, I got two parts actually. One specifically regarding, we had a lot of conversation about the parents and their rights and what they have to go through, and working at the River Valley Hospital for a while, now working with substance abuse treatment, trying to find the right type of treatment for the vast number of things that could be going on in these individuals' lives is difficult. We try to treat the substance abuse first within, IOP, but at the same time, and quite frequently, there's so much more going on than just substance abuse. There's a reason why we're having substance abuse in the first place. And if you look at it, if you look further in, you see that there's this cycle of abuse and trauma that occurred in their lives, which led to the abuse and trauma that's occurring in their children's lives. So at a certain point, we have to recognize the fact that even if they complete the requirements of substance abuse treatment, there's still trauma that needs to be addressed, and parenting right. Those skills that didn't get increased. So it's so difficult to, like he said, there's no cookie cutter on this one. There's so many variables that go into these cases. That's why it has to be. That's why it's so much more complex in terms of what we require of these parents, because they're not all the same. And another one, I had a question for you, Mr. Porter, is what do you see as the main needs for these clients, these individuals that come in and have to wait? Because one of the things that I was doing was helping those individuals for the very brief period of time that we were there. What do you see as their main needs when they come into court?
All right, and I'll go back to two things, back to the old question about what else I do. I forgot, I left out domestic violence and mental health court. We have a grant for both domestic violence, and I have a new domestic violence prosecutor I hope to hire. I have a domestic violence unit that does all the petitions for that, and I have a mental health person who handles all the mental health. So to answer your question, Evan, the biggest thing is drugs and mental health. I mean, those are the two biggest things that we see that need to be addressed. And often they are occurring at the same time, and we need a treatment facility or people like you or whoever who are agile enough to treat both of those. And sometimes you can't treat one without the other. And sometimes if you can't treat the mental illness until the drug abuse is at least addressed. And then that's one of those chicken and egg things, I think. But you all would have to tell me more about that. We just see that a lot. So I think that is one of the big issues is, and the other kind of thing is once we have parents out is right now, how do we let parents see kids? That's another issue, is what kinds of terms and conditions and how do we arrange that so that they can see them? I don't know if I answered your question, Evan, but
I think there needs to be a lot more supervised visit services out there.
yes, because we don't have any now. I mean, the COVID, the virus thing has just reduced the chances for in-person kind of both treatment and visitation or whatever. It's just, I don't know how long that's going to last. And that's going to be a concern as we continue with all of this. What's going to happen to these kids? What's going to happen to parents? What's the relationship? How's the relationship going to change as a result of this inability to see kids, touch kids, that sort of thing?
Okay, we have another question that says, is there any way to speed up a case when parents cannot be found and the children have been in and out of foster care for over 5 years, but the quote official last calendar time is only 5 months?
Whoa, I'd have to look at that. Well, if finding parents is an issue, but normally what we do is appoint a warning order attorney. They have 60 days to look for this person. They file a report with the court, and then we get an adjudication and disposition after that, and that parent can come back in at the time. That's an unusual one where there's 5 years going and we haven't done anything. The cabinet does not like and will not usually accept just a temporary custody order as a sort of permanency. They're looking for an adjudication and dispositional order and APRs. APRs are annual permanency reviews, and planned permanent living arrangements, all those kinds of things. So if somebody wants to send me the names of those, I'll check on it and see what the problem is or what's happened. But that's a little unusual and probably shouldn't be happening.
Okay, we have one that they read about a new mental health court in the paper recently. And how do you think the implementation of the mental health court will affect family court? Do you foresee parents being sent to mental health court based upon their actions or behaviors in the family courtroom?
Okay, so that's another one of my deals, and one of mine. We started that about a year ago. I have somebody who does that. Right now, mental health court entry into the mental health court requires a criminal offense, not a family court offense, not something there. What we do there, we have some people who have families. A large number of the people in mental health court are people who are in supported community living situations or have the cabinet as a guardian. They've been declared disabled and they really can't be convicted of crimes. And so they're in a mental health court to try to get them back onto their medications, realign all those, and try to reduce their crazy behavior in the community and reduce their, a lot of times it's violence, but a lot of times it's against themselves, and a lot of times it's against their caregivers. So there are some possibilities for family court, but those are fairly few because we don't have too many that have the criminal charges necessary to get them into the mental health court.
Okay.
And that's why I say we need a mental health component to almost every one of the drug-related cases that we have. I would guess well more than 50% of the drug-related cases are also mental health related.
All right. As the COVID-19 stretches on, how do you see it affecting the time frames enforced by the court for permanency?
The cabinet's obligation, the court's obligation is after a year or after the parents have not done anything for 6 months or more that there can be a permanency order entered. I think the court is going to and is waiving most of that time period during this virus thing. We had somebody asking for in-person visits the other day and weren't able to set them up. And is that going to count against them? No, we'll make sure that that time doesn't get counted against the time when they're not, in quotes, trying to work on their case plan.
Okay. So as our reviews get postponed and pushed out further and further, as far as that being part of the temporary or the permanent removal from the parents, the TPR beginning, is that going to not count against them during this period? I guess I'm asking, if court stays like this for 6 months, is that 6 months off of their time frame before a TPR can begin?
Probably. I mean, it will depend on each case, because if they're there and they just haven't been able to do it, I think yes. If they've disappeared and they live in Kansas and haven't called and done anything, then I expect it's likely to count against them because they weren't attempting to do anything. They weren't available to do anything.
Okay. Good to know. All right, guys, that's the last question on our chat. Does anyone have anything else? We're wrapping up close to an hour here. I want to give kudos to Evan for parenting and doing a Zoom.
Right.
Kudos to Evan Holcomb. He's been rocking a baby to sleep and maintaining complete awareness of what's going on in our Zoom. So
It's warm in here.
That's awesome. But has anyone got anything else they wanted to ask of Claude before we let him get back to his leisure life?
Thank you all for what you do. We appreciate everything you do, and it's helpful to have all that. I know the court is really happy to see all of you all and see the reports and things, and it's always helpful to get that other perspective.
Thank you, Claude. We appreciate that. And thank you so much, in all seriousness, for taking time out of your extremely hectic schedule to be a part of our Zoom today. Hi, Karen.
Hey.
We all know all about you. You don't know us, but we know all about you.
Well, I love Rosemary. Love everything y'all do.
Thank you. We appreciate it so much. But we appreciate everybody being on today. Charlotte, thanks for taking time out of your busy schedule of getting our checks written to be a part of that.
Right.
We really appreciate it. And we will, next week, we are having Erica Wade from the center is going to be on with us. I believe we're scheduled for Wednesday at 10 or 11, somewhere. It's in the morning. But we'll send out a Zoom invite for that as well. And she is the one that will inform us of all the resources that she offers there through the center. So that should be very, very purposeful as well. So thank you again, Claude. Thanks, everyone.
You're welcome, Susan. Thank you all.
Thank
you very much.
Thanks, Todd.
Bye, guys.
All right. Thank you.